Good morning, everyone. Thanks to all of you who have joined so far. I think we're probably going to have a couple more people logging in within the next couple of minutes. But I think we should get started just to make sure we don't overrun on today's session. So my name's Rumney. I work in the communications team here at the ASA. So I'm sure you've probably received lots of emails from me in the past about our training and events. Today I'm joined by my colleague Sam, who works in our copy advice team over at CAP. And today is the third session in our Influencing Responsibly series that we are running. Today's session is going to be focusing on content itself. So we'll be providing you with an overview of some of the areas where influencers should take particular care to stick to the rules, including when to support claims with evidence. So we'll look at health claims, references to beauty products, and weight loss regimes. And we'll also take a look at how influencers can run competitions in a fair and clear way. Before I hand over to Sam, just to give you an overview of how today's session is going to work, Sam's going to take you through our guidance and rules, and then at the end we're going to have time for a Q&A. So if you have any questions or you think of any questions in the meantime, feel free to pop them into the chat box. And then what we will do is during the Q&A session, I will read out some of your questions, and then Sam will be able to provide you with a little bit more detail on that. So that's it from me. I'm now going to hand over to Sam, who's going to be taking you through today's content.
Thank you very much, Rumney. Yes, as Rumney said, I work on the copy advice team. So we give pre-publication advice to advertisers, agencies, etc. So I'm going to give you an overview of some of the common issues which come up in the content of influencer advertising specifically, and hopefully enable you to identify potentially problematic content before it's published. Sorry, just trying to skip to the next slide, but it's not. There we go, it's just being a bit slow. So as I understand it, some of you will have attended both my colleague Emma's webinar on labelling earlier this year, and later my colleague Justin's, which covered targeting on social media. If you missed either of these, we've got lots of guidance on our website covering both of these important topics. Labelling is something the ASA regularly receives complaints about, and recent action taken by the CMA relating to this has brought it more into a lot of people's attention as well. Issues around targeting in any media can sometimes result in ASA rulings which attract headlines. For example, there are stricter rules around their advertising of gambling, alcohol, HFSS, which apply to influencer advertising as much as any other media. And the ASA will take firm action on breaches in areas like this, where it seems likely to cause harm or be inappropriate to children or issues like that. So in this webinar, I'm going to cover some of the most common issues and to advise how you can ensure that influencer advertising complies with the advertising codes. So this is a fairly short session, so I'll give an overview of where we sometimes see issues and with the content of influencer advertising, and hopefully give you some pointers to keep in mind and label you to more quickly spot problematic content before it appears. I'll aim to stick to around 30 minutes, as Rumney said, and we can go through some of the questions you have afterwards. I should say we're going to go through quite a number of different categories, not all of which I'm particularly specialist in, so there might be one or two that I have to advise you to come back to us at a later date, or come through the copy advice team. Someone with more specialist knowledge of one or two of the areas may be able to help you more specifically. So we won't go into detail about what constitutes an ad for the purposes of the code, but essentially the rules we'll discuss today cover anything where there is some form of payment, either monetary or payment in kind with products, services, etc., and where there is some element of control over what an influencer is saying. Some more information about the remit of these rules can be found on the website in the guidance around labelling and making clear when something is an ad. So we'll start with a look at misleading advertising. So section 3 of the CAP code covers this and contains rules about general misleadingness. In each case, the ASA will assess an ad from the perspective of the average consumer, which is taken from the consumer protection regulations, which the code reflects, to determine how claims within these ads are likely to be interpreted by the people to whom they're targeted. This interpretation can be affected not only by how claims are specifically worded, but also how they appear or displayed in a particular ad and how they interact with other elements there. So an average consumer in consumer law is taken to be one who is generally reasonably well informed, observant and circumspect. And obviously the ASA will take into account the likely audience for particular content. So in short, ads shouldn't materially mislead. This principle, as I say, is underpinned by consumer protection regulations and relate to whether an ad is likely to adversely affect a consumer's transactional decision. This applies equally in influencer marketing as anywhere else. While the style might be more conversational, the ASA would still expect care to be taken to make sure consumers aren't misled. This is perhaps particularly important here, given the potentially high trust followers may put in influencers, and making sure claims around the efficacy of products, pricing or availability is going to be important for both ensuring consumers aren't misled and for ensuring the authenticity of the influencer isn't negatively affected. So in general, marketers, so that's the advertiser and the influencer, would be both contacted if the ASA investigated a complaint, must hold documentary evidence for claims that consumers are likely to regard as objective. The level of substantiation will depend on the type of claim, but basically the stronger the claim, the more robust the evidence needed. So misleading advertising, there are lots of different sections to this, and there are very specific rules on any comparisons made in advertising. Again, these all apply to influencer advertising as much as anywhere else, and there is quite a lot of guidance on our website and in the rules about ensuring that comparisons are fair and the circumstances where they need to be verifiable or that a consumer needs to be able to find out how to verify these. And as you might expect, there are specific rules and guidance on prices and ensuring that those are made clear and any comparisons there are fair. But in general, just make sure that there's sufficient evidence for any objective claims being made. And one or two of the sections that we'll go on to talk about in a minute are ones where a higher level of evidence is likely to be required. So going to some of the rules in section 12 of the code, which covers health, beauty and medicinal claims. These rules reflect relevant and current legislation, but also include other rules in relation to misleading advertising. So it might be that the ASA would look at these rules in addition to the more general ones on misleadingness. These cover any claim referring to a potential benefit to health, to references to medical conditions, which for the most part can only be made about products licensed by a body like the Medicines and Healthcare Regulatory Agency or an equivalent official body, as well as claims concerning beauty for which clinical evidence is likely to be required. And again, the stronger the type of claim, the more substantial evidence is likely to be required there. As with all the subjects we'll touch on today, various more detailed guidance is available on numerous subjects related to health and beauty, cosmetics, etc. And that can be found on our website, as well as more information about the level of evidence and substantiation which is likely to be required for different types of claim. For example, specific health claim or anything referring to a medical condition is obviously going to likely need very high substantiation and clinical evidence, one with concerning a cosmetic may require slightly less clinical evidence like that. Whether these claims appear in more traditional media or if they're included as part of spoken or written content by an influencer, the rules remain the same, and all of these claims should be based on sound evidence. So this is the first and overriding rule in section 12 of the code. Objective claims must be backed by evidence, if relevant, consisting of trials conducted on people. Substantiation will be assessed on the basis of available scientific knowledge. So further on in this section, rule 12.18 is also worth noting here. Marketers must not use health professionals or celebrities to endorse medicines. Although this rule is not often considered by the ASA, and not many rulings exist, this is a rule which demonstrates the importance of ensuring the trust of followers and consumers more generally is not exploited, and the relatively new situations and media which the ASA has to apply the same long-standing rules and principles to. When the wording of the code rules were developed, I think over a decade ago, it obviously not been anticipated that social media influence would develop in the way they had, and that marketers would want to use people largely unknown to the public other than via the social media to promote goods and services. But again, the same rules apply here. Word on medicines. Medicinal or medical claims can only be made for a medicinal product that's licensed by the MHRA or equivalent body, and it's a claim considered to be that the product being talked about or one of the constituent parts can be used with a view to making a medical diagnosis or treating or preventing a disease. And there are obviously very strict guidelines around making any of these claims. So these are some of the highlights of the rules, and particularly ones that that we have to consider in terms of influencer advertising in the copy advice team, and which the ASA will sometimes look at complaints about. Marketers should not falsely claim that a product is able to cure illness or malformations. References to the relief of symptoms or the superficial signs of aging are acceptable if they can be substantiated. So again, because that's a cosmetic claim rather than a medical one, a reasonable level of evidence will be required, but perhaps not as much clinical studies and the background there. And claims like cure and rejuvenation are not generally acceptable, especially for cosmetic products. They're likely to be a problem if they're made there. So while it might be relatively easy when producing more traditional advertising material to ensure that claims like this are avoided, inevitably and understandably, it's likely to be more difficult in less controlled advertising, like a video produced by a vlogger or influencer, and therefore particular care needs to be taken. Again, when a claim appears in a press ad or as part of advertising presented by media, by an influencer in the middle of organic video content on social media, the rules remain the same in both cases, and the same standards are applied. So it's even more important to plan carefully and make sure there's clear communication between a brand and influencer about what can and can't be said, what evidence there is for particular claims. So this case study is one where the rule discussed in the previous slide was applied. So last year, the ASA received complaints about this social media influencer and the references of her experience with an over-the-counter medicine to treat short-term insomnia. It was established during the investigation that the post fell under the definition of advertising because it had been paid for and controlled by the brand that was detailed in the post. And the ASA's role in a case like this was to establish whether the blogger was a celebrity for the purposes of that code rule. and whether the post endorsed a medicine by a celebrity and therefore in breach. So a lot of you might be familiar with this one, but she had 30,000 followers and regularly provided those followers with recommendations on various different products. So although the number of followers could be considered relatively small compared to many other social media accounts, the ASA considered she had the attention of a significant number of people, and so was a celebrity in this context under that code rule. So I think the key learning here in terms of that particular rule is perhaps for us more than agencies and those working with influencers, is to not get distracted by the numbers of followers. Although it was a factor in this case, it was not the sole basis of the upheld decision and will not be the sole basis of future ASA decisions in that area. The ASAs like to take the view that when a marketer specifically chooses an influencer because of their purchasing power over the people that follow them, then this influencer will be considered a celebrity in that specific context and to those specific followers under that code rule. So I'll cover this briefly just because it comes up a fair bit in our team's work. Botox and other prescription-only medicines or POMs. Botox is and long has been a prescription-only medicine, and therefore it cannot be advertised to the public. CAP has undertaken quite a lot of project work. My colleagues in our compliance team have done this to remove advertising in breach of this rule, both on websites and in social media, including through influencer advertising. But there are obviously still breaches out there, and it's not understood by everyone. And we're obviously continuing to take action to address these. Hashtags, it's worth mentioning, are considered part of an ad, so claims made in them can be considered by the ASA. So adding hashtag Botox or hashtag BTX is likely to break the rules and will end up with the ASA or CAP taking action. So some of my colleagues in the copy advice team have got far more specialist knowledge of a specific area than me, have produced quite a bit of guidance and advice on how to ensure that advertising sticks to the rules on this, about ensuring that you're advertising a consultation at which an appropriately qualified practitioner might assess and advise on the right treatment rather than advertising the treatment or the prescription-only medicine itself. And obviously that consultation could include the prescription of Botox or another POM, and that can be promoted in line with the code, but it's obviously you have to be particularly careful in that area to ensure that the specific rule here isn't breached. While primarily designed for those directly offering anti-wrinkle treatments, the approach in all this guidance is one we recommend for influencers advertising such services as well. And again, the copy advice team, or more specifically my colleagues who know a lot more about Botox than I do, are available to help on the specifics of this type of advertising if you do need more help on this. So moving on, just to talk about weight loss claims and dieting claims. Efficacy claims, as in any sector, must be supported by clinical evidence, and the promotion of weight loss products or regimes must be socially responsible. The ASA is likely to take into consideration the most likely audience of influencer, and as you'll see in the example in the next slide, any other factors which affect how followers interpret or are influenced by what they see. These ads must not suggest that being underweight is desirable or acceptable. They must promote regimes which are, other than a reduced calorific value, nutritionally well balanced. And there is a specific rule about ensuring that you're not claiming to lose specific amounts within a specific time. When it comes to an influencer using their own experience to promote a product or service concerning weight loss, the claims they make about losing an exact amount of weight must be compatible with good medical and nutritional practice. And again, there's guidance online about that. So with this in mind, we'd always advise that you think carefully about whether there's any reason that an influencer you're working with might not be appropriate for the particular product in any sector. For example, here's a case where the ASA upheld against an ad for a weight loss food supplement because the influencer promoting it was known to be pregnant at the time. And additionally, the ad promoted a specific amount of weight loss in a specific time, which the code doesn't allow. So some complainants who contacted the ASA understood that Gemma Lucy was pregnant and challenged whether the ad was irresponsibly encouraging the consumption of a weight loss product in pregnancy. The ASA also challenged the claim of specifically losing 7 pounds in 7 days because it implied rate or amount of weight loss attributed to consumption of food. And again, we'll move on to some of the rules around food advertising in a moment. So the ASA Council concluded that the ad was irresponsible because it could encourage pregnant women to use the product to lose weight, which would obviously be an unsafe practice. So even though the post didn't refer directly to her pregnancy, the ASA noted there'd been widespread press coverage of the pregnancy and noted comments under many of her Instagram posts made reference to this. It therefore considered the ad's likely audience was likely to be aware of her pregnancy and considered they would understand from claims like I've been staying in shape with my Skinny Cafe products and I love to use them as me as some of the girls have been seeing great results, would imply that she'd been using the products recently in order to lose weight. Council also noted that according to the specific regulations on nutrition and health claims, as the code reflects, health claims relating to a rate or amount of weight loss were not acceptable, as I said. So the advertising code was breached for both of those reasons there. So section 15 of the code covers food supplements and associated health or nutrition claims. These closely reflect the EU regulation on health and nutrition claims, which is legislation the ASA has to take into account when it considers complaints about any advertising of food products. Perhaps more than any other section of the code, the overriding factor here is that by law, any claims made, even in less scripted and more authentic influencer social media posts and videos, have to relate to an already authorized claim on the register. So there's a lot of detail in this section, which we won't go into today, but some of the headlines here. General health claims are those that refer to a relationship between a food or an ingredient and a person's health. That is more general claims about the effect that eating something or taking a supplement will have on the body. These can be made but must be accompanied by a specific claim which is authorized on the EU register of authorized claims about foods and supplements, which is directly, and that claim must be directly relevant to the general claim. This might be for a particular ingredient or the foodstuff itself, and this must again be made clear. As you can probably tell, this is a complex area, and again, we've got lots of advice available on the website, but it's worth highlighting here as something to be particularly aware of when working on the basis of general messaging for an influencer to present in their own style, as opposed to more carefully scripted or drafted copy, which might be more where it might be more challenging to stick to very prescriptive guidelines on claims like this. There's also specific guidance on claims like probiotic, organic, antioxidant on our website. And for many of the claims like this and other nutritional claims, there are clearly laid out acceptable claims and terms of reference on the EU register of health and nutrition claims, which you should always check before making any claim about a food supplement or similar. And again, a copy of Ice Team is always on hand to advise on things like that. So we'll rattle through to promotional marketing here. Some of the key principles when looking at promotional marketing, which can be a competition, a prize draw, or merely a discount code or a sale. The promoter is whoever is running the promotion in a joint or cooperative promotion where more than one party benefits. All parties are held responsible. So, as in the examples I've shown you, the ASA would hold both parties responsible, and if a formal ruling was published, both names would appear on that. So the code also applies to all stages of the promotion, not just the initial marketing, and applies anywhere that a promotion appears. So this is an area where sort of specific remit of the advertising code, as in where the ASA codes apply and where they don't, doesn't really apply here, because the competition itself or the promotion itself is governed by the codes. So it doesn't matter where it's advertised, it's got to comply with the rules. So some of the examples that we see, particularly in influencer advertising here, all of these would be covered by the rules in Section 8 on promotional marketing, special discount offers and discount codes, buy one get one free offers, limited time offers, competitions or prize draws. So all marketing communications referring to promotional marketing must communicate all significant conditions, and that's termed as in where the omission of that condition or information is likely to be misleading. And this again applies to any media or context in which an influencer is promoting an offer or prize draw. Significant conditions, as defined here, will vary on the type of promotion, but regardless, they must be prominent in all advertising, positioned close to the headline offer, and a link to full terms and conditions must be used. So how these are presented will differ on different platforms, and in the past, the ASA and CAP have advised that there may be occasions where advertising is so severely limited by time or space on social media that not all significant conditions could be included. This is less likely to be the case now, and less so on as platforms develop and allow further creativity by users and influencers. For example, at a basic level, an image containing significant terms and conditions or any rather relevant information could be included on a platform like Twitter, avoiding the character limit, or superimposed text can be used on other platforms, allowing information to be made clear. So Rule 8.17 goes on to set out some of the examples of things which are likely to be considered significant conditions. A few of these are on the slide now. Closing dates, which I'll go over in a moment in another example, are a particular issue which shouldn't be changed. And sort of some of the justifications given by advertisers are generally not accepted to change closing dates, generally not accepted by the ASA. Oops, sorry, skipped too fast there. So again, just to be clear here, these are some of the other areas that the rules, there are specific rules on, and which we haven't got time to cover in full today, but there are specific sections of the advertising code and are worth keeping in mind when advertising features anything like this. And motoring, if there's anyone driving in an ad, even if it is an influencer as part of more organic content, if there's driving shown as part of something that's going to be considered advertising, there are rules concerning excessive speed and dangerous driving. Environmental claims, as you might expect, a high level of substantiation required for green or sustainable claims. And areas like e-cigarettes, where there is legislation the code reflects, there are strict rules on the promotion of these. Let me, and just a quick word on the the rules around social responsibility. Again, everything listed here on this slide are all issues which the ASA is likely to consider in breach of the code when they appear in influencer advertising as much as anywhere else. So some key points to sum up, and we've gone through a huge amount of information in a very short time there, but hopefully some will stick in your mind and you can find out more about anything that's particularly relevant for you. Make sure you hold evidence for any objective claims. Be aware when working in more complex areas around health, food or age-restricted products, and take particular care with competitions and promotions, including terms and conditions, and make sure everyone involved, all parties involved, stick to the rules. I will hand back to Romneet now, who will take you through some of the areas where you can get further help on this.
Brilliant. Thank you, Sam. We are going to take questions in a minute. I appreciate we've run over a little bit, but just to give you a little bit more information about where you can get additional advice and help from us, we are on Twitter, ASA and CAP, if you want to give us a follow. We have got regular newsletters that go out. So our insight newsletters are full of guidance from the copy advice team on differing topics. So sign up to those if you'd like to receive those first. We also run regular training seminars. We've got one coming up in December on digital advertising. So we'll be looking specifically at the rules on social media and other digital platforms. So if you found, the information today helpful, definitely have a look at that, because that might offer you a little bit more information and insight. Like Sam said, we've got our copy advice team that Sam works on. So if you ever have any queries or need to run anything past us, they're the team to get hold of for that. And we've also got our e-learning modules as well. So these are online training modules. So if there's a specific topic that you're really keen to learn more about, or you think that your team could benefit from, have a look on the CAP e-learning website. We've got lots of different modules. So we've got ones on misleading advertising, promotional marketing, social media, a really wide range of topics. And we're running a 3 for 2 promotional offer at the moment as well. So you can get a discount on those too. But for now, I'm going to just have a look and see what questions have come through, and we can go through those. So question from Alina. Alina has asked, what evidence would be considered as sufficient for ads on the internet? For example, for marketing statements about our marketing online tool. So what evidence would be considered sufficient for that?
Well, it'll kind of depend on the nature of the claim being made. So some of the sectors that we discussed in brief just now, health and claims around food, are going to require a very high level of substantiation, and there are specific documents online about that. If it's more general sort of comparative claims and not in those particular sectors, then well, it really does depend on the nature of the claims, really. But ensuring that you've got supporting evidence of any pricing claims or comparative ones. Yeah, there are quite a lot of different documents online about claims like number one and other comparative claims like that, about the evidence and data that would need to be held. There are also particular rules around verifiability, which I won't go into detail here because it's another fairly complex topic. But if a comparison is being made with a competitor's products or something like that, generally the ASA requires that consumers can find out how to verify those comparisons. So a link to a website or something like that where details of the evidence to support those claims is found. But yes, if you've got specific queries about the evidence you need, you're very welcome to submit that to the copy advice team.
Perfect. Thanks, Sam. Another question from Nisha. So how do you determine whether a claim has been substantiated by a retailer? What types and or amounts of evidence are required?
Well, I think I probably covered quite a bit of that in my last question, in my last answer. Really, I think it will depend on the um, kind of claim being made in the sector that's being discussed. In terms of if this is from an influencer's point of view, so said both parties, so the brand and the influencer, would likely be contacted if the ASA undertook an investigation or received a complaint about something. In most cases, it will obviously be the brand who will hold that evidence and provide that to the ASA to justify their claims. And again, I think it comes down to sort of ensuring there's good communication between both parties, so that they're both clear on what can and can't be said, and what, and only making claims where there's sufficient evidence.
Perfect, brilliant. Thanks, Sam. Amy's asked a question here. So she said YouTube is planning on changing their terms so that they run ads on some creator videos, but the creator won't have any control over this or receive any money. Wouldn't influencers still be responsible for the advertorial content in this instance?
I wouldn't have thought so. I'd have to look at the particular scenario there, but I mean, what's described kind of sounds more like a normal, sort of a pre-roll ad where it's clear that it'd be separate from the from editorial or organic content, or just like a commercial break, really. If that's the case, and the influencer had no control over that and wasn't receiving payment, I don't think it would meet either of the tests there. So it would be the brand in that advertising who would be held responsible, not the influencer.
Perfect, great. Amy's also asked what deems someone as an influencer, and she notes the particular case of Mama Life.
Yes. Well, as I said, there's a number of factors there. It's obviously going into specific numbers of followers isn't going to be the only thing that's considered. And I think what that ruling tried to draw out was that there might be a very specific audience for this person, but if they're marketing something, there's payment and control, and they've been chosen because they're going to have what the brand thinks is a positive influence over people's buying decisions. That's going to be considered advertising for the purposes of the code. So I don't think there'd necessarily be a discussion about whether they're an influencer there. It would just be advertising.
Perfect, great. And I'll just take this final question because I'm aware we have run over, but this is from Davina, and she's asked, does this apply to PR products and product gifting, as this is technically not a paid for advert?
Again, that's something we've gone into in quite a lot of detail online. So you can either contact the Copy Advice team or have a search for influencer advertising on the website. So we've drawn up quite a bit of guidance with the CMA about where that line is. Basically, sort of talked about that payment and control mechanism. If there is something that is truly gifted, so it's just been a brand sending something out to an influencer with in the hope that they like it and talk about it, but if they're under no obligation to and could just keep it or could say something negative about it, they might not get any more work or anything else sent to them for free. But in that case, it's unlikely to be considered advertising for the ASA and CAP. But the CMA does have sort of a wider remit on that. So there's quite a useful flow chart that one of my colleagues put up as part of the influencer guidance online, which should help me to establish whether it's something that needs to be labelled and which the codes apply to, or whether it's something that the CMA might be able to look at, but which the CAP code wouldn't apply to.
Brilliant. Thank you so much, Sam. And I appreciate some other people may have some further questions. So like Sam recommended, the best thing to do is to get in touch with the copy advice team if you have any specific questions about any campaigns that you're rolling out with influencers. They would be the best people to get in touch with. I will follow up with an email to you all with a copy of today's slides, and I'll include a link to the contact form so you can contact copy advice should you need to. But huge thank you to Sam for leading on today's session. I hope you all found it really useful, and definitely take a look on our website for any further advice and training that you may wish to take part in. Have a great day, everyone.
Thank you, everyone. Goodbye.
Bye.